In this tutorial, we're going to be covering one of the most intimidating part of your paperwork, but most important, and that's the real estate contract. Now, in the state of Ohio, we have recently adopted a uniform sales contract, so no matter what part of the state that you reside in, as an Ashmont agent, you will be using this specific contract. Now, depending on the area, geographical area that you might be residing in, there could be some variations to the contract that you might have to tweak. So reach out to your mentor for more information pertaining to that. But without further ado, I'm going to have my colleagues, Bill Fergus, and Stephen McCoy, who were part of the panel that created this document for the real estate contract. They're going to be diving into it. It's going to take about an hour, but they're going to go through the contract and break it down more line by line for you so you can get a better understanding of this contract. But again, if you have any questions, please reach out to your mentor.
John, Bill, and Stephen.
Great. Hey, good morning, Gary. And good morning, all the attendees here, Ohio Realtors from around the state. Good morning to you all. I want to thank everyone for their time here today to learn more about this very, very exciting product that the Forms Committee at Ohio Realtors has put together, polished for several months, and it finally released earlier this year at our winter conference, the first great unveiling. So this is part two of the great unveiling of the new statewide residential real estate purchase contract. So very excited for this program today. We've got about an hour and a half, a little bit under that at this point, to get through material that would probably take about 8 hours to thoroughly get through in due course. But with me today, I've got John Deegan and Bill Fergus, as Gary duly introduced. They are two experts who participated in the Forms Committee for the time period in which the contract documents were prepared. And then I jumped in about last January, and helped kind of carry the torch to the end of the finish line here. But we're very excited to unveil the contract and go through it in great detail for you all today. So first, what I wanted to do was obviously start off with, talking about who our panelists are. We've got our lovely faces on there. I feel like my face has aged a little bit since this first photo was taken. I will blame that on the contract. But really, we're going to go over the process just real briefly, and then provide an in-depth discussion of the contract and the addenda that our Forms Committee has put together. We do want some questions to come about, so feel free to drop those in the chat. We will do our best to monitor those. We realize this is a very large attendee list, so we will do our best to get to every single question, and we will leave some time at the end for additional Q&A. So feel free to drop those in the chat. We'll try and monitor those, and we'll also have some time at the very end to open it up for questions and answers. So first, before we get into the meat and potatoes, I want to start everyone off with a little appetizer. What was the process in which we arrived here today? So as was mentioned, this was a process that really started in about 2019, when a task force was created to study and examine the process of having a statewide residential purchase contract for our members to use. That task force led to the recommendation of creating the statewide contract. In fact, there was a poll that was sent out to all the brokers around the state, and the overwhelming majority, close to 70% of all the brokers who responded, indicated favorably that they would want a statewide purchase contract and documents to be put in place. So as a result of that recommendation, the Forms Committee at Ohio Realtors got together. It was composed of several different people. We have, as you might know, we have 5 districts delineated on the Ohio state map around the state. And from each of the 5 districts, we had 2 representatives. Most of them were real estate brokers, but also the 2 attorneys that are on this panel today, Bill Fergus and John Deegan. They gracefully lent their time to a really rigorous endeavor. So we're very grateful for all of the Forms Committee members, including Noreen Marlowe, who was the chair, Tim Stanford, Shannon Hill, Susan McAllister, John Deegan, obviously, Jenny Stoops, Mark Kottman, who's our 2023 chair, Dan McQuillan, Todd Book, and Bill Fergus, Sally Linder, and Sue Price. Of course, we would not have gotten where we are today without three very, very important people, Peg Rittenauer and Lori Garland, the two longtime attorneys who were guiding the ship for decades and decades at Ohio Realtors. Ohio Realtors brought on myself and Todd Book last year, so we are the two new attorneys trying to fill the void, the vast void that was left by those two industry stalwarts. So Peg and Lori put a lot of time and effort into creating this contract, so we would not be here today without a lot of their effort, for sure. And of course, Erica Jones, who attended every single meeting for the Forms Committee, which resulted in a little bit over 1,000 total volunteer hours by all of the members on the Forms Committee. So a huge shout out to Erica Jones, who assisted all of us and assists all of you on a daily basis as well. So let's get to the high level overview, given those introductory remarks. And really, we go over the time that's spent and the number of people that were involved for a couple of reasons. First, this wasn't something that maybe I just drafted on a rainy afternoon and are now sending it out to everyone. A lot of eyes, a lot of hands, a lot of brain power and time went into creating these documents. We've considered just about all the alternatives that could be discussed under the sun. And by way of that, we created sort of a Frankenstein of the best practices from around the state. So without further ado, let's jump into the documents. Really, the first thing I wanted to do for everybody who's watching today, hopefully you're seeing my screen, and you're seeing the homepage for ohiorealtors.org. If you're wondering where these forms are, there's a couple ways to get to it. I'll show you the easiest way to get to them. So you just go up to the top here. If you follow my mouse, we have a legal tab here. You'll hover down, go to legal library, and go to legal forms, and then you'll click. Once you click, it takes you to our homepage for all of our legal forms, but featured most prominently, I think for very good reason, is the new residential purchase contract and all the addenda. With these documents, we've also provided fillable, or what are known as interactive document forms. So these are fillable that you can plug and play onto your computer and really fill out the fields that are meant to be filled out interactively through the PDF there. We have a couple other really good resources, but this is really how you find those documents as you're looking through these. So without further ado, let's kick it off. I will go over just a couple early sections of this contract, then I'll hand it off to really our two stars of the panel today, John and Bill. But first I wanted to introduce the documents, and then we will dive right into the meat and potatoes. So first you'll notice on the front page, it introduces the general definitions and terms of the contract. So these are the definitions and terms which are going to be used throughout the body of the contract. We do this for a couple of reasons. A, to simplify, but also so that everyone's on the same page as to what the meaning of these terms are. So for example, you might see the singular form buyer when there's multiple buyers, and we meant to include that the term buyer and seller includes all persons or entities that are purchasing or selling the property. Okay, so that really, for simplicity's sake, we wanted to put that as buyer and seller in the singular form. And then obviously, I think kind of the two biggest areas to point out are the date of acceptance and days here. So how are days defined in this contract? So, some contracts will indicate, these are, 5 business days or, 10 calendar days. And you really have to pay attention to each clause. We decided to standardize this. So we've made this portion of the contract in practicing real estate easier. All days, all references to days in this contract means calendar days, including holidays. So that's important. You're not having to guess or pull out a calendar and be overly complicated with it. Days means calendar days. So when you're setting up the deadlines or setting forth the time periods in which people need to respond or provide documents, it needs to incorporate calendar days. And that needs to be a discussion with your client to make sure that they can meet those deadlines in a timely manner. The other important definition, in my opinion, is the broker. You'll see references to the seller's broker or the buyer's broker. This includes, without limitation, the brokerage and any affiliated brokers and agents involved in the transaction. So we meant to include, we didn't want to differentiate broker and agent. They are included in one and the same term throughout the body of the contract. And then lastly, earnest money is referenced as EMD. And so as you see references to EMD, we are referring to the earnest money deposit. So I really wanted to kick things off. The first two paragraphs here. The first paragraph, this is universal in all contracts. Identify the property. What are we buying and selling here, guys? So you will include the street address, including the city, the county, the state, and the zip. Okay. Parcel numbers, parcel ID numbers, very, very important. You can always confirm those using the MLS or obviously the county auditor's website. Very easy to use in all counties around the state. And this is important because there are some types of properties who have a greater risk of having more than one parcel ID number associated with it, particularly in rural areas or even condominiums. There could be a unique parcel ID number for, say, a parking spot. So making sure you have all the correct parcel ID numbers is critical here in line 18. And again, MLS or the county auditors, a great way to verify those. We do have another line for further described as. So if there's not maybe a clean property address, there is another method and mode to describe the property. If it's a certain acreage on a certain part of land, that would be appropriate to put there to help further identify the property that's the subject of the contract. The second piece here goes into financing. So you've identified the property in paragraph 1. The second paragraph talks about how they're going to pay for it. That's always important. So we have three main options here: paying cash, financing through a lender, the traditional way, or C, kind of a non-traditional financing. That can be, land contracts, seller financing, and so forth. So really the three big ways: cash, traditional financing, and then the third section on the other page here. It's important to note that with paying cash, if you are going to indicate that the buyer's paying cash here, that the buyer needs to deliver evidence, and that's listed here on lines 23, 24, that they have evidence of readily available liquid funds necessary to complete the transaction. So if they're going to be paying cash, they're going to need to produce some sort of evidence. Usually that's like a brokerage statement, a bank account statement with, obviously some of the account information redacted. But just some sort of written evidence satisfactory to the seller about the readily available liquid funds in order to purchase that property. Okay, so that's an important distinguishing fact there. If they don't receive it, or if it's not satisfactory to the seller does have the opportunity to terminate. Okay. A second portion goes into the traditional financing. If buyer is going to be working through a third-party lender, it provides a financing contingency to obtain financing for the purchase of the property. Obviously, both of these are initial here type of setup, so make sure that the parties initial there, place their initials through .loop or your e-signature platform. You'll put the number of days, 7 days if left blank, and we always try to include these if left blank options. So just in case you miss a field, there's always a saving grace there for what we think the traditional standard time period should be. So you will put the number of days there if 7 isn't satisfactory or if it's different. You'll check mark the appropriate loan product that's being asked for by the buyer. And then you're able to put additional financing terms and conditions. This isn't required, but there are some parts of the state where it may be advantageous for buyers to include their down payment amount or some of the loan terms, including the loan to value ratio, to help kind of make their offer a little more attractive. So that's an option there. Some parts of the state incorporate that. And that's really a theme that you'll notice throughout the contract, is that this was meant to capture the best practices from around the state. So if something isn't done in your area, don't sweat it. This is really just meant to capture all the different practices. Lastly, it goes through the loan commitment period here. So, like with most loans, a lender will produce some sort of a loan commitment. So they will commit to loan on the property in this transaction, usually provided that certain conditions are met. Or in the alternative, a lender will provide a denial or a notice of termination, basically denying the loan there. And thus the notice of termination will come from the buyer. So you basically have those two options there that need to be met before the loan commitment period that's set forth here in lines 42 and 43. And then, of course, 2C, this is the other financing. So really, this would be used in maybe like more non-traditional setup. So say the seller is actually going to provide financing themselves. So it's going to be a seller finance type of deal. Or land contracts or some other kind of unique financing situation. We've got the section for you. So don't sweat that. So really, I think that's a great kind of opening and introduction to the contract. But I do want to hand it off to our two panelists here, and I will help moderate us as we go. John, if you want to kind of kick us off here, obviously if you have any opening remarks, but also I'll have you cover the first two contingencies in 3 and 4, please.
Yes, actually, I'd like to get right into it because I know it's going to be tough getting it in the next 60 minutes. The next paragraph I'd like to talk about is the appraisal contingency, a provision that's in the contract, paragraph 3. And we noted even before COVID, there was an accelerated use of escalation clauses. And most brokers that drafted an escalation clause, at least if not in the beginning, shortly thereafter, built in an option for clients to put in some type of appraisal contingency to, I guess, gauge whether or not they were excessively overpaying for the property. We thought it was a good idea and not to have a separate addendum, but to incorporate that provision in the statewide purchase agreement. And so in paragraph 3, it provides not automatically, but a buyer, when writing their offer, can make their offer contingent upon an appraisal by a licensed appraiser up to the purchase price. If they do use some type of continued use of escalation addendums, which has occurred through the COVID phase of our past 3 years, they will have to make sure that that escalation addendum reflects not only the purchase price, but any escalation from the offer price to the purchase price. Some of the problems we've had in this is how long can this last? This, you'll note in the contract, it says if the property appraises for less than the purchase price, the buyer may terminate by delivering written notice and a copy of the appraisal to the seller no later than 5 days from the receipt of the appraisal. So we didn't want this to linger. We wanted to have an opportunity for the parties, if they're going to kill the contract, to provide whatever necessary documentation they have so that the seller has the option to understand what had happened and can quickly put the property back on the market. So you'll note that they have 5 days. I'm going to refer to that 5 days as one of the 17 or 18 trigger dates that are in the contract, and we'll talk about that at the end when we talk about time is of the essence. The parties can also, sometimes people read their own current brokerage contract, or they're going to read the statewide contract as if it is the Bible on real estate and that nothing can be amended or changed. We wanted to put something in the contract that told the parties that they may, at their option, reach a written agreement to adjust the appraisal or adjust the price, so that it does give the parties still the opportunity to keep the deal alive, even if the appraisal fell short of the purchase price. It does say that the buyer has to deliver that waiver within the time period in order for that time period to be effective. It is not an automatic appraisal contingency. You'll note in the beginning, it has to be checked, one or the other. So if you are yourself going to use this or train on this, or if you use an electronic software program for your contracts, you may want to talk to the software provider to see if they can get that to stop at those type of questions, to make sure those are answered either yes or no, and it's not left blank. If it's left blank, the agents leave the door open for a client saying, we talked about this and I thought we had it in there, as opposed to leaving it blank. You would check the box not contingent on the appraisal, because you want to make sure, as best we did in this contract, to make sure that the buyers and sellers understand their expectations of what they agreed to at the time of the contract. So that is a opt-in or opt-out appraisal contingency, and it is not our advice that those yes or no, is or is not checked. Like so many parts of the contract, if it's left open, it's left open to discussion. If it's left open to discussion, it's left open to a lawsuit. So make sure when you look at that portion of the contract that you check one or the other, depending on your client's wishes. The next paragraph is the real property closing and sale contingency paragraph. We expect and we hope that with a more stable market that people can actually make their offer contingent on their house selling, as opposed to being stuck to make it with no contingencies as the market is kind of dictated. But we also wanted an opportunity for it to be in the purchase agreement and not just on an addendum. Sometimes if it's just on an addendum, it's not presented to the client to understand what their options are and what they elect to do as far as contingency. So paragraph 4 allows a buyer to elect one of two type of contingencies. It's subject to the closing of a property that's already on the market and under contract. And the other one is it's subject to a home to go on the market and closing and not currently under contract. We will talk at the end of the webinar about the 4 addendums that come with the contract. And one of them is the real property sale addendum, which we highly recommend is a part of the contract because it further outlines the obligation of the parties, when they have to deposit the funds, when they have to have their home inspections, and the seller's rights and notices provisions within the contingency paragraph. So we would like to talk about that at the end. We will probably reference back this particular paragraph when we talk about the addendum, but we wanted an opportunity for the agents, you and your client, to talk about the option of a contingency. Whether the market will permit that or not is a different subject.
If I can add something here on the appraisal contingency.
Sure.
So this is one of these things in the contract. There are several that are drawn from the Columbus Realtors standard contract. And the main purpose of having an appraisal contingency is to protect the buyer from a bad lender appraisal. So let's say the contract price is $250. And it appraises at $210, in those circumstances, the buyer could be obligated to bring $40,000 cash to the closing table that they weren't expecting to bring, and they may not be able to do that. So that's the main purpose, though. The way this is drafted, cash buyer can use it too. They just want to make sure the property's worth what they're going to pay for it. Yeah, that's all I wanted to add.
And yes, I appreciate that, Bill. And it also is a flexible tool. Again, these are pre-printed contracts, and we're trying as best as possible to come to a contract that works for both sides. But if your client is willing to set the appraisal at, as long as it appraises for, instead of the purchase price, they can put a different provision in there if they're willing to understand what the significance of that is. Bill's example is to make sure to purchase for the purchase price, but the buyer may be still willing to pay for that. They just may have to come up with more money. So they could change this appraisal contingency to say no less than, and they could modify that. And we'll talk about an addendum to do that, change it from purchase price to something else if the market conditions require that. It's not often that comes about, but they have to understand that the sometimes when I talk to an agent, they'll say, well, that's what the law is. That's why the contract's written that way. Well, it's meant to be flexible. And if parties understand that they want to change it from something other than purchase price, they certainly can.
Yeah, and great points, John and Bill. It looks like we have several questions in the chat. I know we want to address a couple of these, and then we do need to move on, and we'll try and save a lot of these for the end here. But there's a question about it's not mandatory to use, so how will these be put in place? So yeah, we couldn't necessarily mandate this from the state level. Really, this will be dictated by your brokerage or your local board to require it, but from our state standpoint, we don't require it. It's not a mandatory to use. I mean, some brokerages and local boards want to continue to use their local contracts, and that's perfectly fine. We just made this tool available to help people who maybe are looking for something a little more polished that captures a lot of different practices and is a thoroughly drafted document. But any other insight on that?
Well, I would like to address to this audience, the vast majorities of states in the United States have a statewide real estate purchase agreement that is drafted and promoted and offered by the statewide Realtor Association. We're not blazing new ground in the United States here. We're actually, an effort was made, and I learned through this committee, it's been going on for decades, to kind of bring some consistency around the state so that, you've heard the old phrase, I have a statewide real estate license, but it makes a difference in where I go and what the terms and conditions of a purchase agreement are. And I think over the expansiveness over the last 5 or 6 years in this business, everybody's selling in different MLSs in different counties. And there's an expectation that even to our clients as buyers and sellers, it shouldn't vary between a buyer and a seller of what realtor they pick and in what county they're in, that the terms and conditions change. And so this was an effort by OR to kind of bring some cohesiveness to selling real estate in the state of Ohio, that it's a contract that works no matter where you go. And that you don't have to worry if you're in Cleveland that, do I have the right contract for Montgomery County, or if I'm in Cincinnati and I want to go up to Columbus, to have a contract that everybody kind of knows and understands and works with my client, so that it doesn't become an impediment to getting your client to get the property they wish.
Okay, great. Well, if I can interrupt for one brief moment, it's time for us to share our first CE code word. So, Stephen, if you could please throw that up on the screen, and attendees, please do not post this in chat. But this is your first of 3 code words. So please take note of this. You will report this to us following the program. There is a link in your confirmation email for you to send in the code words. You'll have up to 24 hours after today's program to submit the code words. But this is the first of the 3. The first code word is Ohio. So please take note of Ohio. And with that, we'll move on.
All right.
Okay.
I definitely want to make sure everyone gets the code word. This is your ticket to the CE credit, so make sure you jot that down. All right. Well, let's get back to the contract.
Okay.
Really, we wanted to pick up at the next paragraph here of 6 involving earnest money. John, you want to take us away?
Yeah, I do. This is a subject that it seems unusual, that is a repetitive issue, both with brokers and risk management. And also with the division, earnest money, how do you hold it and what do you do? This is probably the great explanation of how to take care of the issues that we've seen as an industry. And that is, we've defined the person that the money is going to be with as a holder in different parts of the state. It's a title company. It could be a law office. In other areas, it could be a title company. So in order to allow this contract to flow in other markets, we've defined the third party holding the money as the holder, and it could be any party. It could be the broker. It doesn't mean because it says holder, it's not the broker or the title company. And it also sets what I consider one of the 17 or 18 trigger dates in the contract, that 3 days, if left blank, or the parties can agree to a different amount of days, on when the earnest money shall be deposited with the holder. And it also says that if the third party is someone other than a real estate broker holding the earnest money, the parties may have to execute or sign some type of escrow agreement with the title company or the law firm or whoever's going to be holding the funds. They may have their own individual escrow agreement. The biggest significant paragraph that was added that's not been generally in any broker's contract is the next paragraph that says, within 5 days after the earnest money deadline indicated above, and it would be 3 if it's left blank, the buyer or the buyer's broker shall provide written confirmation to the seller or the seller's broker that the earnest money was received by the date required. That is probably an unspoken rule that the division is always surprised that brokers are not complying with some type of notification. And it says if such notification is not received, it gives the seller a legal opportunity to terminate the contract because it wasn't received. So in this contract, and again, we picked 5 days. We didn't think it would be appropriate to leave that to the discretion of the parties, but within 5 days after receipt of that deadline, if the buyer's broker is required to provide written confirmation to the seller, that is a discipline that's been going on from the division, that agents who are not appearing before them or following their decisions probably are surprised to find out that the buyer's broker has to provide notification of the default, and that the seller's broker has an obligation to tell their client whether or not that's been taken care of. In this particular paragraph, it provides the vehicle to comply with the regulations imposed by the Division of Real Estate, and that is a 5-day notification in writing. In writing can be text, it could be email, but it has to be some type of written confirmation that the funds have been deposited or not been deposited. And then that triggers the seller's right to terminate the contract and move forward. We've had this situation as an industry where if the buyer doesn't deposit the money, is that a material breach? Is that a breach but not a material breach? What does the seller do? The buyer keeps coming up with days and excuses and reasons why they don't have it. In this particular contract, we give them the opportunity that if the seller doesn't want to hold beyond those 3 days after not receiving written confirmation of the deposit, they have the ability to terminate and put the house back active on the market. I'm sure we'll have some questions on that.
There's definitely a couple questions here, and it's important to note that earnest money simply it's not required to have a legally binding contract. It's really more of a custom. So there was a question here as to whether it's required, and no, but it's just such a custom around the state that it makes complete sense having this in here. But it's not a requirement to have a legally binding contract.
It is not, and agents should know when they're talking to a client, the client probably always says to them, how much do I have to make the earnest money? I think one little note to keep in mind, in the state of Ohio, you can go to small claims court on $6,000 or less. So if your client's deciding on whether to put $6,000 down earnest money or $8,000 down earnest money, you have an opportunity to go to small claims court. If it's 6 or under, that means you don't necessarily have to hire an attorney. But anything over $6,000 is going to require that you go either to municipal court or a state court if it's over $25,000. And that incurs additional costs. So when you're talking to them, obviously they have to decide what number they want to put in, but that is certainly a relevant number to keep in mind when they're talking about how much do I need.
Exactly.
And then the last paragraph in this section is the standard provision that we're going to hold that money if there's a dispute until we receive a court order or written instructions by the parties instructing us how to proceed in the event that the transaction does not close, which has been pretty common in the last 10, 12 years in brokerage contracts.
And also it complies with Ohio law on the subject. So if a broker's holding it or a third party such as a title agency holding it, it makes no difference whatsoever in how that earnest money deposit's handled. It's all going to be handled pursuant to the state law that applies to brokers.
Yeah, earnest money, it's a hot topic. I mean, we get a lot of questions on it on the legal hotline about, disbursement, but also at the division. It's a frequent violation of releasing earnest money when you don't have written instructions and so forth. So we really try to outline the provisions of 473524 in this paragraph. So, and we also, as John mentioned, that 2-year language here to return the earnest money is also included. So that's taken care of in this contract. That's really to help kind of clean the slate when it comes to holding money for years and years.
And like Stephen said, earnest money is not a requirement for a valid contract. So up in line 73, if a party wanted to make their earnest money maybe not subject to a home inspection, but probably as a result of the home inspection or after the home inspection is released, they can certainly have an addendum that does that. I'm not sure a seller would necessarily agree to that in these market conditions, but they might. But you could also indicate that you can pick the number of days. You could say earnest money is going to be deposited in 14 days or 21 days. It is not law that it has to be 3 days. We just picked 3 days because that should be about the amount of time somebody is writing an offer and doesn't happen to have their checkbook, or they don't happen to have a way to electronically transfer funds into the broker. So there's a great latitude of that window, depending on the market conditions, which are still pretty tight in listings. So I assume it's going to be short, and it's going to be a lot of money on the earnest money. But that's an important, the biggest difference in this contract compared to most of the brokerage contracts to date is it didn't provide a remedy for default to a seller that quickly.
Definitely. So yeah, it has that seller remedy if it's not deposited. So that goes a long way in kind of help clearing up some of the questions that can come up during a transaction and reinforces really the position of the division of reporting if something does not get deposited in a timely manner.
Yeah, and this class is just about talking about the contract, but it does give the seller the ability, if the buyer has not performed under the terms of this paragraph, to instruct their agent to put the property back on the market as active, because it gave them the right in the contract to terminate it if those events did not occur.
Right. Okay. Okay, well, great. Yeah, thanks, John. That great overview of the earnest money. It's a very important paragraph, so we really want people to pay attention to it. We've got a fair amount of questions on here. So let's see. So a title company holding earnest money would require an additional escrow agreement. So we make it that the parties agree to execute an escrow agreement if they're going to be using a third party other than a broker. The terms of that escrow agreement should only supplement but not conflict with this paragraph. So we're basically having it so any third party holder we're all subject to the same standards and rules about how funds are going to be dispersed. So this helps standardize the practice, and really I think most title companies will err on the side of caution and actually mirror 473524 anyways. Because it's a very clean, easy way to understand the disbursement of earnest money, keeps folks out of trouble so no one's guessing. So that's important too. Okay, well, go ahead.
We do. At Northwest Title, yes.
Definitely, yeah, it's a good idea too. John, want to carry us through fixtures and equipment?
Yeah, so this is another perennial repetitive problem that we were hoping to eliminate the risk of in drafting this paragraph for future use by agents. And that is, this paragraph is an exhaustive list of a lot of items that is only surpassed by our list for condominiums and HOAs. But we tried to put every conceivable description of fixtures that we may think could be in a property, but not limited to this list. And that is, a lot of times buyers see what they see when they go through a house, and they're either talking to their agent or they're not, and they're expecting certain things are in there. Sometimes it's a matter of certain things were listed in the MLS, but they're not paying the list price. So the seller has an expectation that what was in the MLS doesn't count because they're paying less than what was in the MLS. We wanted to kind of avoid that problem because historically, we never win in these issues. They're usually smaller amounts of money that we end up having to contribute for goodwill than it is our responsibility. So we kind of put together a list that we had two choices. We could either do this list of all these exhaustive things that would normally be considered fixtures, or we could give them Stephen's general definition that says, if you turn the room upside down, anything that fell down is not a fixture. And so Bill and I erred on the side of being more specific. And so we put this list together. I've got a lot of feedback that said, are you kidding me? Is this list? I said, we could have made it longer. Everything's a balance. So this paragraph kind of goes into one of the points of the statewide contract, and that is to make sure we're consistent across the state on how you handle fixtures, but also make sure the parties understand what is their expectation, what's coming or what's staying. And this would give a seller to say, no, cross it out, knock it off, send it back to the party if they want to keep stuff. I mean, I've had certain cases that somebody said to me, why do you have landscape? I said, I've seen people take trees and bushes out. They planted a tree or bush in memory of somebody who died, and they may or may not have ever told that to the listing agent, but it was gone when the buyer showed up. So, why this stuff is in here is because we've all had issues with this stuff before, and we were trying to find a list of stuff that would, help you to sit down with your client when you're writing an offer, help you when you're sitting down with your seller saying this is their expectation of what is staying and not staying, instead of putting the burden on you at 11 o'clock at night to come up with a list of stuff. We listed them for you, and you can either leave them in or scratch them out and initial them if that's important. I think the biggest thing too, in addition to items, through 151 or whatever that number is, the first round, is there's a whole category of leased equipment. And with the advent of everybody selling homes all over the place, there's a lot of people that never lived in a home where there was leased equipment. And now they're selling properties with leased equipment, generators, water softeners, could be refrigerators. So we wanted the option to put in there solar panels, water conditioning systems, the ability for the seller to indicate what items are leased. Too many times we've had buyers move in and they came home only to find somebody, tearing the Generac off the side of the house or showing up to take the water softener or the solar panels out. We wanted the ability for the parties to understand, to identify what issues are leased and which issues are not, and which are coming that are leased, and have the discussion about what that lease payment is, because sometimes it's not always in the MLS. And then in between that paragraph, I jumped over that. We did talk about equipment that should be in the same location and condition and working order. We've had certainly people take the kitchen fridge and put the garage fridge in there and say, I told you I was giving you a refrigerator. I just didn't tell you which one I was going to give you. So again, it's an opportunity for you as an agent, having gone through the home with the buyer, trying to understand, is this what you want? Was there a washer dryer? Is it going to stay? And the document says condition to be in working order. And that's meant to say to a listing agent sitting down with the seller, hey, is there any problem with these appliances? Because in the contract, you're indicating that it's in working order. So that's the opportunity to kind of clean things up and say, the washer's working, but the dryer isn't, and you hang stuff up. So it is exhaustive looking. But again, one of the tenets of this contract is to try to limit as much as possible your risk going forward in the marketplaces that you're in. And we felt this was a a minimum of what needed to be in there when we're talking about fixtures, so that when you're writing that offer, you don't have to pull up the MLS, see what fixtures are in there, or guess at what they said at the open house about what's staying or not staying. So, any important questions popping up on the fixtures, Stephen?
Yeah, great overview. So a lot of the questions kind of center around, items that aren't listed in this list. And this is really meant to just be kind of a starting point. If there are unique, equipment or fixtures, maybe not in this list, but it's a pretty exhaustive list. But if there's anything that's not listed, here in 164, you have the opportunity to add those things. So if you have questions like, oh gosh, I'm not sure if it's actually included in this list, feel free to just add that in line 164. Again, this is just meant to be a really great starting point. We don't anticipate a lot of deviations from this, but if there is, we've provided that ability to do that. So you can add equipment or fixtures in 164. You can exclude items, fixtures that aren't going with the seller. So just make use of some of the provisions and lines that we have in there as well.
This is, whenever I teach a course on a contract, this is a paragraph that you have to concentrate on. There's some risk here, because the problem is that Ohio courts do not define very well the difference between a fixture and equipment. They will tell you that a fixture is something that's so affixed to the premises as it becomes part of the premises, but that kind of begs the question. The few court cases that are out there talk about divining the intention of the property owner as to whether they intended the fixture, this particular item to be fixture or equipment. So we've tried to make this as exhaustive as possible to narrow down those issues. But as both Stephen and John said, they're never going to get completely resolved. So you do need to be careful about this. If your buyer wants something that's not on this list, you need to list it. If your seller wants to keep something that is on this list, or for that matter is not, they need to list it in a counter offer.
And 165 also permits them to write exclusions. I think Bill's point is really good, and Bill and Steve and I have joked about this. You're going to have that conversation. You can either have that conversation standing in front of a court in small claims court when the court's asking you and your clients what the understanding was of the agreement, and it usually ends up blaming us as an industry. Or you can have that conversation at the time of contract and get it all over with and not have the problem and not go to court. So it's really kind of meant to promote the discussion and have that understanding up front, as opposed to a misunderstanding about what was included going forward.
And as you mentioned, John, most of these things are never going to see the court. We're talking about $500 to $1,000 typically, something of that nature. It's certainly not enough to hire an attorney over, but you're going to end up with unhappy people on both sides of the transaction, yep. And that is very bad for business for both agents.
Right. Yep.
All right, gentlemen. Well, let's in the interest of time, let's skip ahead here. Bill, you want to walk us through the inspections and test paragraphs? Okay,
thank you, Stephen. I'll try to be brief here because I think we're falling behind a bit. So when you look at this, just going down through it in paragraph 9, we have lots of bold cap CYA for brokers. So you are strongly recommending that they conduct inspections, and at the same time talks about the fact that the broker doesn't guarantee or assume responsibility for condition. It's all broker CYA, which is all well and fine. So we should be doing, certainly protecting you. Big things to look for in this is note that there is a choice of inspections. Some parts of the state, so look at 9A, 1 or 2. 1 would conform more to what happens in central Ohio. Number 2 conforms to some of the, I've seen this in Cleveland area contracts and some of the rural areas where you're picking and choosing your inspections. Note that there is an inspection period under 9B and a remedy period under 9C. If you want to scroll that up a little bit, Stephen.
Sure.
These are some of the 18 odd deadlines in the contract that John was talking about. And these are really hard and fast deadlines. There's some things that can be finessed, but as an agent, if you miss one of these deadlines, you don't timely inspect the premises or have the premises inspected or timely deliver a request to remedy defective conditions, you got a problem on your hands. Because the buyer's in position where the seller's in position say, well, that's great that you sent me this a day late, $1 short, but I don't have to pay attention to it. You're in contract. Note that the buyer drives, as I like to say here in Columbus, the buyer drives the bus. So the seller really doesn't have to do anything in this paragraph. And so they receive a request to remedy, they can just sit on it. And we have this 3-day default provision in here for the period of for them to consider or negotiate any request to remedy. If you get to the end of that 3-day period and nothing has happened, as the buyer's agent, you have to impress upon your buyer that they have a choice as to whether to waive their request to remedy or allow the contract to terminate. So it's important to pay attention to that. Couple other things here. Note that there is a requirement for licensed inspectors. I think this is a big upgrade. This is one of the few things in any residential contract that is really purely seller protection. This forces so if you don't have this in place and an unlicensed inspector, which could be legally could be the buyer's Uncle Joe who does this for free. Now, Uncle Joe doesn't know beans about inspections, but he does his inspection anyway, does a bad inspection, notes defects that may or may not actually be present. Now the seller's got a real problem on their hands, in terms of disclosing defective conditions to the next buyer out there if this terminates. So this at least gets us in a position where all the inspections should be at some level quite legitimate. Then note paragraph 9F. For those around the state who aren't from the Cleveland area, this is primarily a Cleveland suburb thing. The inner suburbs of Cleveland, such as Euclid, Cleveland Heights, and the like, they have these point of sale inspections in order to maintain property values, and they require that properties be brought up to code before the transaction can be completed.
Yeah, I'll follow up on that because that's up in my market area. For those in the greater Cleveland market area that are used to point of sale inspections, this is an important paragraph to pay attention to before you meet with your client, or if you're a listing agent, before you meet with your seller, because this is saying that the seller will deliver it point of sale compliant. If for some reason the parties want to negotiate that, and if for some reason the particular city permits buyers to assume those, then you're going to want to pay attention to this paragraph if you're a listing agent, and make sure that you understand the default in this contract is that the seller is going to pay for all point of sale requirements. It doesn't mean you can't negotiate that. You just have to strike this provision and have an addendum that reflects how and when they're going to share those point of sale violations. And then specifically to what Bill was talking about, the licensed home inspectors, keep in mind that if we as an industry pick somebody that's on the licensed list, approved list, state licensed list for home inspectors, and if we as an industry give 3 names, we have statutory immunity to the negligence of a home inspector. So if you pick somebody that's not state approved, or you give somebody without 3 names, we lose that statutory protection and immunity if that home inspector does a less than proper home inspection or report. And then finally, that 9G, I'm surprised that when we brought this out, how much feedback I've gotten from agents who said, what do you mean the buyer's responsible for any damage or destruction that was performed during a home inspection? And I'm kind of taken back by, well, of course, if somebody comes into your home and breaks something or does something or pulls wallpaper back, that you're not the owner of that home. If you close and assume that, okay, but if you don't close because of that home inspection, you, the buyer, and maybe you, depending on how it was explained, somebody's responsible for restoring the property to the condition it was in before the home inspection. So that's in the contract. You need to be aware of it so that if something does happen at a home inspection, you're able to immediately point to that provision to say the contract requires Mr. Buyer or my client that you and or whoever did that restore the property to the condition it was in before you had your inspections. Yep. And then finally, I did want to point out to the northern market that may be not aware of this, but 9A 1 and 2 is important to pay attention to because we currently, by default in our market area, use contracts that list these home inspections and you pick which one you want. This contract gives you an either or. You can do what we would call the standard Northern Ohio or, which is 9A2, or you could, on behalf of your client, talk to them about just 9A1. And that's kind of more of like a commercial due diligence. You decide, and you got to make sure your timetables are right and how much time you have to get that all done. But you can say, at buyer's discretion, sole discretion. So that gives you a little more latitude on what you can get done, as opposed to, we always get the, what happens if you pick general home inspection and you didn't pick mold, and then the home inspector said, I see mold, you got to get a mold person in there. If you pick 9A1, as long as your timetables are accurate, you don't go beyond what I'm calling trigger dates, you could have multiple people come out and take a look at it. So you need to pay attention to that and understand that this contract gives you an option to do an either or.
And note that this is a custom and practice thing. It varies around the state too. Yep. If you use this contract in the Columbus market, people, the listing agent is going to be very comfortable with someone checking number 1. If you're going to Athens or perhaps Cleveland, people are going to be more comfortable with number 2, for example. Doesn't mean you have to do it, but right. It's that comfort level when you're dealing out of market.
Okay, well, if I can interrupt for a quick moment, it's time for another CE code word. And you can see on the screen there, our second code word is realtors. So please take note of that. And again, do not post this in chat, but following our program, click on the link in your confirmation email to report our 3 code words. So thank you.
You guys are making this awfully difficult.
All right. Yeah, great points there. There's a lot to consider there, and really just make sure you're checking the right boxes. Talking with your buyer client about the inspection process and which inspections might be appropriate, but let the buyer make those selections. And then if there are any changes, so I saw some questions about inspection costs. So some situations in which a seller will pay for a certain cost, just address this in an addendum or the additional terms. We have a specific paragraph towards the end for additional terms and conditions, so you can indicate there if sellers are going to be paying for a specific inspection or an addendum is appropriate. But yeah, if that is the situation where seller will pay for certain inspections or tests, depending on the loan product or the circumstances, just make note of that in the additional terms or an addendum. Okay, we're gonna skip ahead a little bit. We were gonna talk about the off-site conditions and property use, but I think we want to skip ahead a little bit since we're behind. But really, this reflects some of the current law with respect to off-site conditions, and making sure that we're really putting the onus on the buyer. If they're concerned about something that's not affecting the property directly, but it's off-site, that's on the buyer to investigate those conditions. So we have some additional CYA for the seller and also the brokers as well, to really make sure that the buyer does their own research here and their own due diligence. Let's skip ahead though to property taxes and assessments. There sounds like there's as we learned through the process, there's a couple different ways to calculate taxes when it comes to closing and how those taxes are prorated. Bill, could you explain really the two big ways of calculating such prorations?
Yeah, and let me, before I get to the proration methods, let me point out one thing here so when you look at the first part of paragraph 13, it says seller shall pay or credit at closing, and many of these things are fairly common sense stuff, but note number B in particular, letter B in particular, all assessments which are a lien on the property as of the date of closing. I don't know that this is the same all over the state in terms of custom and practice, but it's the way we did it in this contract. And what it means, for example, is that let's say that your municipality is going to put sidewalks and street lights on Main Street, and they assess all the property owners on Main Street for that. And the assessment, let's say it's $10,000 to be paid over 10 years, and you are in year 2 of that assessment. What this means is that at closing, the seller is going to have to pay the balance of that assessment, the balance of the $10,000 that's due. This is important. Sellers need to know this. You don't want them to have a nasty surprise at the closing table where, of course, you will get blamed as the buyer's agent, whereas actually in this case as a seller's agent. So that's important here. Now, as far as the proration methods, in most of the state, when you look at letter A, that is how property taxes are prorated. So you look at the entire period prior to the date of closing. If you're in day 184 of 365, and the property taxes have yet to be paid on in arrears on the first 180, on that 184, which you probably haven't, then that's going to be the basis for your proration is 184 over 365. In Montgomery and Lucas counties, that's Dayton and Toledo and some surrounding areas, they use what's known as a short proration method. In the short proration method, without getting into the gory mechanics, the bottom line is that you're prorating off the last tax bill rather than for the entire period. And the real bottom line is that it's advantageous to the seller and disadvantageous to the buyer, relatively speaking. However, it is fair to the buyer when they become the seller, as long as you keep doing it going forward. So these markets have had the short proration method in effect for over 100 years, seems to have developed out of the great floods. I think it was 1912. And they're going to keep doing it because as long as you keep doing it, it's fair. You stop doing it, seller is getting back both ends. Now, one other thing, community development charges, they're different than assessments. State law requires this to be in the contract. Of course, the buyer writes the contract and the buyer is going to have no clue, generally speaking, as to this community development charge, and the onus is on the seller to provide that information. Community development charges are handled like taxes, not like assessments. So like when we prorate community development charges, they are prorated to the date of closing, not being paid forward, because usually they were paid over a very long period, 15 to 30 years typically.
Yeah, great points, and it really kind of outlines exactly, as Bill mentioned, the two primary modes of proration here. So the default here is the long proration method. That's described here in A. We do address agricultural use tax recoupments. I saw a question in the chat on that. So that is paid or credited at closing. Obviously, if the parties want to negotiate that, they're free to do so, but we needed to set some sort of standard there. And then, with community, with the short proration method, that's really only used in, I believe, about 2 or 3 different localities in the state of Ohio. So if you are in that area, I believe it's Montgomery and Lucas counties, maybe Greene as well. If you are in one of those localities that uses a short proration method, you will have to affirmatively check the box there to make sure it's prorated using that method. Otherwise, if you don't check anything, if the default is the long tax proration, which majority of transactions will use.
And this in particular is one of those portions of the contract where you might want to have good communication as a buyer's agent with the listing agent. Say, are you in a market that uses short proration? Right, it's that simple. Are you? Yes, no. Check the appropriate box then. I don't think this is something that you want to leave open to negotiation necessarily. This is one of those custom and practice issues that is only fair if you continue it in a given market. So yeah, communication with, and there are a number of areas in this contract where communication with the listing agent while you're drafting your contract is a good thing.
Yeah, absolutely. Well, great. Yeah, great points there. In the interest of time, let's move forward to the Owners Association. So this would involve property that's subject to either a homeowners association or a condominium owners association. John, why don't you walk us through this one for us?
So yes, in the interest of time, I won't go through all these documents that are required in here, but some of them I'll highlight. The practical problem when we're selling condominiums primarily, and PUDs or HOAs can also fall into this category, is that we know that there are governing documents that dictate how and who can live there, what can be there: dogs, trailers, work cars, sheds, gardens, whatever. It's important to understand that all of those documentation recorded to the house and to the development are enforceable. And so what we prepared is a list, and it starts off primarily for everybody to review that list, whether you're a lister or a buyer's agent, to understand the type of documentation. And I think people's initial reaction is, are you kidding me? That's what happens when you put lawyers on a contract committee. But the practical side is each and every one of these documents that we have listed in this contract are important. Each of them can affect how much it costs somebody to live in a condo or a PUD or an HOA, and what they can do and what they can have at their property while they're living there. This type of year, people tend to get ready to get their boats or their campers out. There's associations, you can't do that. You can't park them in your driveway, or you can do it for 24 hours or whatever the issue is. And so take your time and read through this list. It's important. It's a good education tool if you haven't sold a condominium or a PUD or an HOA to understand what needs to be there. And it's also a really critical piece of information to talk to your client about when you're getting a listing on a condo or a PUD, to say, this is the type of documentation where I am going to need from you, and the buyer is going to request from you why this contract is pending. We set a timetable, and the seller is going to agree to provide within blank days. We put 7 if there's nothing in there. So if the parties want to make it shorter or longer, they can. To provide those documents. And then the buyer has 7 days to review and accept those documents. We know practically as an industry, a lot of these documents that are on this list may not be available, at least at the speed at which properties are being sold. And so if a listing agent can, while they're getting ready for the listing to do coming soon or back on the market, if they can get their client to get a hold of their property management company and say, here is the list from the statewide contract that I'm going to probably be requested. Please provide me with this documentation so I can share it with any future buyers that are coming in, because they're going to need this and have to make a decision on this. And then from a buyer standpoint, expect that you should see this documentation when you're within 7 days of your offer, and to review it. It should never be your responsibility as an agent to go get those documents, to make sure those documents are all complete and up to date. And nor should it be your responsibility to review those documents and advise your clients on whether or not you're going to be able to comply with all those documents, or more importantly, that whether you have all the documents that are requested on the on this contract for their review. It really needs to be the responsibility of the seller, and then it's going to be the responsibility of the buyer to make an educated guess. Do they have enough information to go forward? Some of the big issues that they're going to want to know about, and I don't mean this by a limiting phrase, but they're going to need to know, is there any lawsuits against the association? Are there any arrearages in the association? What is their, do they have a capital reserve plan? And if so, how much is that? All this documentation is really both from experience and also which is required by federally insured lenders, that this information be available to the underwriter before they make their underwriting decision on the loan. So it's not overly exhaustive. It's what we really consider a minimum amount of information. We know the practical reality is it's hard to get this stuff. Sometimes it's hard to get your condominium association management company to respond to this stuff, but it's important for you to understand what needs to be available to your client to make educated decisions going forward.
I would only add that so looking at this whole list, it's hard to make a decision without the deed restrictions, any rules and regulations of an association, and especially if you're dealing with a condominium, the money, right? In a condominium situation, you're marrying your fellow residents. There's no love involved, so you want to make sure the money's right. And if they're not holding sufficient reserves, if they're not funding a proper reserve fund, as is generally required under Ohio law, your buyer within a short amount of time could be in for a very nasty surprise, say a $10,000 assessment to repair roofs or something of that nature. And once again, who's going to get blamed, right? So it's important that these things be obtained if at all possible.
Yes, and I don't want to overemphasize from a risk management standpoint that it's not your responsibility to get these documents, and it's not your responsibility to tell your client that these are all the documents. These may be the only documents you currently have. It doesn't mean they're all the documents. And so you want to make sure that you have proper documentation on this information. Have the seller provide the contact information and share that information with the buyer to contact the condominium association, whether it's self-run or they have a company doing it, and let them get to know the level of response they're going to get from their condominium association as an owner up front. And that way you're not responsible. And too many times the agent tries to do everything they can from a customer service standpoint to take care of them. And when they don't have all the documentation, the buyer looks at them like it's their fault. Like, I relied upon you to go get me all this documentation. It really is an unreasonable burden to assume as a buyer's agent. This really is a seller disclosure requirement. And a buyer wouldn't ask you to do a home inspection on a property. And that's the equivalent of saying, go get me all the documents I need for a condo. And so we're trying to put this in the contract so the parties, the buyers and sellers, understand what type of documentation they're agreeing will be provided and reviewed before it goes forward.
Yeah, so just to kind of call out the three really kind of important items, and as John mentioned, this is not meant to be limiting. These are all very important documents, but the declaration and deed restrictions, which has the rules and regulations, information about whether there's any pending lawsuits against the association, and also the financial statements. In my opinion, I think those are some of the three most important items, at least from this list, but that's not to say the other items are not important. They certainly are. Okay, well, let's skip ahead here to the title search and title insurance paragraph. So there's obviously a lot of conversation about this, how things are handled differently around the state, and even the two different products that we have listed on the page here. So Bill, real briefly, if you could give us maybe a couple of minutes of just the title search and title insurance, the differences between these two products, and the paragraph in total.
Okay, so this is the ultimate flexible paragraph in the entire contract, because as many of you may be aware, custom and practice regarding the provision of title insurance and even who selects the title agent vary very significantly around the state. So rather than coming down on the side of any one custom and practice, we've left this one wide open to potentially negotiation between the parties, potentially following a local custom and practice. For example, here in Columbus, we mandate the provision of a homeowner's policy if available for the property, and we mandate that the seller pay for it. In Greater Cleveland, correct me if I'm wrong, John, 50-50 split is the custom and practice. Buyer selects the title agent. In fact, I'd say in the rest of the state outside Columbus, buyer selects the title agent. In Cincinnati, Dayton market, the seller is providing a $300 credit towards the provision of title insurance. Buyer pays the balance. In most of the rest of the state, you're looking at a situation where if the buyer wants title insurance, they can pay for it. So that drives the whole thing here, really. A homeowner's policy of title insurance, incidentally, is an enhanced coverage product that costs about, I believe it's 10% more than a standard policy, but has some forward-looking protections for the buyer, whereas traditional title insurance is a backward-looking product. In other words, it insures the state of title at the time of closing and nothing beyond the time of closing. And in the interest of time, I think that's about all I'm going to say.
Yeah, very good. Yeah, there's probably more to say there, but really, yeah, there's two different products. They cover different things. I think most folks will use the standard owner's policy. But for folks who are interested in learning more about the enhanced policy, we have the standard language here that the buyers encouraged to inquire about the benefits. Refer them to a title agent so they can go over those options. But really, this is the enhanced is for more. It's like an enhanced protection that would be more forward-looking as opposed to the standard, which is backward-looking. So great overview. And then obviously a very simple breakdown of who pays for it, because that can vary in the state. We will skip ahead. There's a property survey paragraph, so you can make this transaction contingent or not contingent upon obtaining a property survey confirming the boundary lines. And then also with FERPTA, dealing with situations in which a seller is deemed a foreign person under the Internal Revenue Code, which is more of a tax issue. They'll have to withdraw or withhold 15% of the amount realized by the seller before that gets dispersed. So a pretty substantial paragraph. If you feel or if you learn that your seller is a foreign person, that should be a very upfront conversation with your clients. If they are, definitely want to consult or get them to a tax professional as soon as possible to discuss that, not last minute at the day of closing.
Two things there. Ask the question. Okay, are you a U.S. citizen or have a green card? And to every time when you take a listing, and B, realize that the 15% that Stephen discussed, when they talk about amount realized is one of those IRS terms of art. What it means is 15% of the entire purchase price. So it's real money for real people. This is not a surprise that your seller needs to have, and it could be a surprise they potentially can't meet at the closing table. If it's say 15% of $400,000, we got a lot of money there, right? Do they have $60,000 coming out of this transaction to be able to send off to the IRS?
Yeah, absolutely. That could have a pretty big impact on the transaction. Surprise, you have to hold back tens of thousands of dollars that you might not have.
Yeah, it could kill it. That's what it's down to.
So the last paragraph we want to talk about in this contract is the closing paragraph in 20 here. John, could you walk us through that in the next minute or two?
Yes, and I want to throw in, if we have time to talk about times of the essence too, or no?
Yeah, we will. Go ahead.
Okay. Yeah, the closing paragraph is another one of those custom and practice paragraphs that we had to blend on how it's done over different areas of the state of Ohio. And the paragraph 20 talks about a date. Again, that's another trigger date that we'll talk about for closing. And then you're required to initial one of these. And this either or is really more of, it's kind of like the long and short tax expiration. In your market area, if all the necessary documents are signed and a transaction is funded in half of Ohio, that's considered the closing date. In the other parts of Ohio, it's that date following all the documents signed by the parties and the sale proceeds have been dispersed to the seller. So you would check either or, and you could check it either or and different than how you do it in your county, but it was really meant to allow you on how you practice closing in your general custom market area in the state of Ohio. Some areas, once all the documents are signed and the title company verifies that the transaction has been funded, consider it closed. Other areas, they require disbursement of funds to the seller. So this is more an adaptive, customary paragraph to your market practice.
Definitely. Yeah, so again, another difference in custom around the state is addressed here in 20. So make sure you mark the correct one, or have your client's initial the correct one there in 20. The last provision we just want to bring up in the last closing minutes here is time is of the essence. So let me scroll down here to paragraph 33. This is line 455. We decided to add this bold language here that I've highlighted on your screens. Time is of the essence as to all dates set forth in this contract. John, you want to talk a little bit about that?
Okay. I know it's the end of the class. Pay attention. There are 17 trigger dates in this contract. And trigger dates meaning we picked a date for something. This provision in this contract on page 455, line 455, means when you said March 27th, it's March 27th. Okay? Not if you're on spring break in Siesta Key, not if you decided to go golfing. it's March 27th. That doesn't mean the parties can't agree in writing to change those dates. Again, it's not saying it's not fixable. It's just saying if you don't have an agreement between the parties, that date is that date. And if you don't hit that date, it can affect the enforceability of the contract. We in my Northern Ohio market area, we've never done with that. It's really been all around and about because of the flexibility of the industry. This is a significant change. This thing you have to pay attention to. This you have to make sure you have each of those trigger dates within a time frame, and a text email message between two agents agreeing on a modification of the dates doesn't count. You will need to have addendums, amendments that are changing these dates in order that you don't affect your client's ability to enforce the contract or have the contract enforced against them. Very significant switch.
Let me add briefly to that, when you go into contract, the agents need to put their heads together and exchange documents specifying when all these trigger dates are going to happen. You do not want to have a situation where where somebody thinks they've reached day 10 of the inspection period and the other party says, no, it's day 11, you're out of luck. Agreeing on all this in advance that, we confirm that these are all the dates that these things should happen, and exchanging paper with one another on that, just between the agents, that have to be signed by the parties, is going to eliminate a lot of problems.
And this paragraph has to be read alongside the definitions of dates, date of acceptance, and dates after acceptance. And that's why some people will look at those definitions in the beginning and say, what is this, like garanimals for real estate? No, it's because words have meanings, and we've defined in the beginning of the contract dates after acceptance. It starts at midnight that next day. So date after acceptance, all of that is defined. So you have to read time is of the essence in these trigger dates in light of those definitions and know what those end times are. As Bill said. Yeah.
Definitely. Well, thank you both for your time and walking us through this.